a very different statute than the one at issue here.
But the governing language, admittedly, the references to duties in Section 232A, 232C does not refer to them, and the court didn't refer to 232A at all, or the phrases duties or tariffs analysis. What it held was the phrase adjust imports, which includes a verb that's narrower.
But it was in the context. It was in context of activities that had to do with raising and lowering duties. Here, the verbs that accompany regulate have nothing to do with raising revenues in the form of taxes.
And counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really keyed to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think if you read the opinion, first it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history. So it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
Well,
Congress is not bound to use that particular formulation when it wants to confer this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor's statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain